Hi AI class, it's Professor Opterbeck, and in this video I want to talk about the current version of the draft CCPA regulations on automated decision-making technology. And we've been looking at a draft from 2003 of these regulations, and you'll see in this current draft, which is actually more recent than the 2023 draft that we've been looking at. So this current version was subject to a hearing in the middle of January of 2025. There was a public comment period, which has just closed on February 19th, 2025. And we are now waiting to see whether and if and in what form California may issue these regulations. We may have final regulations as early as this April, or maybe not. We will see. But let's talk a little bit about what this current version looks like. And within this current version, we have an admixture of regulations on cybersecurity, including cybersecurity audits, which we aren't really focusing on in this class, and the automated decision-making regulations. So we have here a definition of artificial intelligence, and what I want you just to notice about this definition is it relates to the idea of inference. And if you recall, the EU AI Act is doing a similar thing with its definition. So whatever that means, the ability of the system to infer. And we have a definition of the technology of ADMT, of the kinds of technologies that can use this sort of inference. It's phrased broadly to mean different kinds of software programs and different kinds of applications, and including the activity of profiling. I also want to highlight these two definitions. So a request to access ADMT means a request that the business has to provide certain information about the technology, and we'll look in a minute at what that information would be. And then a request to appeal ADMT, which is the right of the consumer to appeal a decision that ADMT has made. And again, we'll look in a moment about some of the circumstances under which a consumer can or can't request that kind of appeal. So when we look at Article 11, Section 7200 of the regulations, we come into these proposed regulations specifically about automated decision making. And notice that the regulations are going to apply, the requirements are going to apply when the ADMT is making a significant decision about a consumer. And when we talk about a significant decision, there are some exceptions, but essentially what we're talking about is the access or provision or denial of certain kinds of services. So financial or lending, housing, insurance, educational opportunities, criminal justice issues such as bail, employment or other work-related opportunities, healthcare services, or essential goods or services such as medicine. And there's some definitions of what education and employment means in this context. So, you should see that these general kinds of things, again, are the sorts of things that also the EU AI Act is concerned with, activities where the AI is making important decisions about people having access to basic kinds of goods and services. And so what are the substantive requirements for these kind of uses of ADMT? The substantive requirements are what the regulation is calling, or would be what the regulation is calling, a pre-use notice. So this is a notice the consumer has to have before the system is used with respect to that consumer. That is providing information about what the system is going to do, about the consumer's right to opt out, and about the consumer's right to access the system, and about the way the system is going to be used and how the system works. So the opt-out is not necessarily the most controversial part. There are certainly questions about whether and how someone can opt out of automated decision-making if it's being used as a practical matter. But one of the really controversial things has been this access requirement, and including these information requirements about how the system works. And notice the language here, the logic used in the system. So there's a lot of questions here about what kinds of transparency has to be required, has to be provided, and how far the company has to go in providing information while still also having some kind of interest in protecting its own trade secrets. Again, we've seen this same kind of conundrum with the EU AI Act, but it's the same sort of basic requirement of transparency and notice and a right of opt-out, and raising again these questions of what it means for providing that kind of transparency without disclosing trade secrets or too much of other kinds of confidential information. Now, as to the opt-out obligation, there are some really important exceptions in these proposed regulations. So one of them is if the business is using the ADMT solely for security, fraud prevention, or for safety purposes. This is potentially a really broad exception because a lot of uses of ADMT, for example, in the workplace might be for exactly those kinds of purposes. A second one, which again is potentially really broad and significant, is if the proprietor of the ADMT is offering a right of appeal with a qualified human reviewer. So notice here that the opt-out right is limited if, in fact, human review is provided. So we have the security exemption, we have the human review exemption, and then we have exemptions in the cases where the ADMT is being used for hiring, at compensation or other work evaluation, and educational profiling and evaluation. And these exceptions are consistent with each other. And they require first that the technology is necessary to achieve this objective of the enterprise, and that the enterprise has conducted an evaluation to ensure that it works as it's supposed to work, and to ensure that it does not discriminate on the basis of protected classes. Now, in the case where the enterprise has obtained the ADMT technology from a third party, the third party has to have conducted the kind of evaluation that is required, and the business that is implementing, that is using the technology, has to conduct their own review of the analysis that the provider has supplied. So in each of these cases, there's a necessity requirement, and there is a pre-evaluation review requirement to ensure fairness and non-discrimination. As to the actual requirements for the opt-out, they're pretty extensive. You can see the business has to provide at least 2 methods of opting out, and there are numerous requirements for how prominent that has to be, things like not requiring the consumer to create an account with the company in order to opt out, and when the request needs to be acted upon. And concerning the request to access ADMT, you can see also that the regulation is pretty extensive as to what kind of information the business is supposed to provide. And these include the specific purpose for which the business used the ADMT, what the output of the ADMT was with respect to that consumer, how the business acted upon that output with respect to that consumer, and how the technology worked with respect to that consumer. Probably this fourth one, as to how the technology worked, is one of the more challenging ones. It's easy enough to say, yes, we used it. Yes, it gave us a decision, give you a loan or not give you a loan, for example, and we acted on that decision. We gave you the loan or we didn't give you the loan. But then to look into the putative black box and to determine how the system worked. So you can see that this puts a requirement, if you're going to use this kind of technology, to have a good idea of what kind of parameters it's going to be using to make that decision. In other words, it really can't be a true black box.